Rachel is a long-standing member of the Green Party. She ran for elective office for Attorney General, I believe, at least once. And did you get over 100,000 votes in the state? No, okay.
I got about, I think it was 60.
Okay.
65,000.
65,000. Also, she was recently elected New York State Chapter Chair of the Sierra Club. So, Rachel Treichler.
And I'm also an attorney from Hammondsport near Keuka Lake in the Finger Lakes, and an activist with much of my time, as Carl said. So many of us are involved in the gas drilling issue and very concerned about the gas drilling because we're concerned about water. And there is now in the New York legislature a bill, two bills, one in the Senate, one in the Assembly, that address fundamental water issues that I think that gas drilling activists haven't been that aware of. So what I want to do with my time is talk about this legislation and give you a little bit of background on the water laws that we have now, which are not that well understood, and explain to you why I think that we're better protected with the existing law that we have and that this proposed legislation is actually to benefit gas drilling companies and other very large water withdrawers that want to take water out of New York and out of the Great Lakes Basin. So let me explain that. I do have a PowerPoint to help illustrate this, and I want to ask Jack Austin from the Coalition to Protect New York to come up here after I've given sort of some background on water law to help discuss the bill, because the Coalition to Protect New York has taken a very great public position asking questions about this legislation. I've handed out two handouts, and I think Jack is handing out another one. The CPNY press release with wonderful quotes from Sandra Steingraber. She's enunciating many of the ideas that Ben and CELDEF have enunciated, who's making the decisions about water, and also a memo of some of the concerns that we will discuss with the PowerPoint. So Ben has talked to us about fundamental rights, and I think one of the most fundamental rights we have is the right to water, because water is essential to life. Without water, nothing on earth would have life. So the rights that we have to water are critical, and they are rights that have been recognized for thousands, if not tens of thousands of years. I've just briefly mentioned the water withdrawal bills that are currently in front of the New York legislature. This legislation is being promoted by some of the large environmental groups as environmentally friendly legislation. That's how it's been presented to our legislators. It is moving quickly through both the House and the Assembly, the Senate and the Assembly. It is now on the floor of both of those bodies and may be voted on as soon as they come back into session on May the 2nd. We understand that the Senate is expected to vote on the bill on May 2nd, which is also the Earth Day Lobby Day. The Assembly may be listening to some of the concerns that have been raised. There's a rumor that the Assembly is considering some amendments to address some of our concerns, so we really urge everyone to contact your representatives, particularly your Assembly members, and raise these issues with them. As we've said, the strong public interest in water has been recognized for generations. We have water withdrawal rights in New York. They're imposed by statute in the environmental conservation law, and they are also established by common law principles established by judicial decisions. The case law thread establishing water law principles, riparian rights principles, come from the English common law, come forward into colonial law and into the law of our state, and originate actually with Roman law. Under current statutory rules, permits are required for public water supplies and for certain other uses such as agricultural irrigation, but mainly for public water supplies. In addition, we have new legislation enacted in 2009 that requires the reporting and registration of surface and groundwater withdrawals exceeding 100,000 gallons per day. But the main laws that we have governing rights to water in New York are the riparian rights established by case law. And the riparian rights in New York are similar to the laws of the eastern states in the United States, including the laws of Pennsylvania, are fairly similar to New York. And basically these rights are rights that are inherent in the ownership of land adjoining a water source. Each adjoining landowner has an equal and correlative right to make reasonable use of the water on the land that adjoins a stream. A riparian right is a right of use. You don't own the water. The water is held for the public. The public owns the water, but the adjoining landowners have a right to use the water, but that right is subject to the rights of all the other users as well. That is called a correlative right, when the various rights are intertwined and dependent on each other. And this is quite a different system than the system in the western United States, which is a prior appropriation system, which gives what are sometimes called hard rights to water. You own a right to take the water. This right can be transferred to other users. It can be transferred away from the land. The riparian rights are rights that go with the land, and they cannot be transferred away from the watershed. Some of this I've already said. I'll skip down to the next to the last point. Reasonableness. In determining what is a reasonable use, a use only becomes, reasonableness is contextual, and it only becomes unreasonable when another user is substantially injured. For this reason, riparian rights are difficult to predict in advance, because it is difficult to predict whether a use will be classified as reasonable or unreasonable. And this is one reason that industry, including the gas industry, don't really like riparian rights, because they make it difficult to plan and to be able to count on that you have a right for water, for very large amounts of water, in for long-term planning, for business planning. So riparian rights do present a problem for large water, potential problems for large water users, particularly if there are projected, if there's going to be less water, not enough water for all the users, and the various users will have to diminish their use. There are uncertainties, long-term uncertainties with riparian rights. And because of the desire, I think it's a desire of large water users to have more certain rights, there's been a push in a number of eastern states to establish permitting systems. These are not as strong of a rights as they have in the western states with prior appropriation systems, but they are permits that are granted by the state regulatory agencies. They're for a certain time period, and they're for a certain amount. And that's essentially what this new New York legislation is seeking to put in place, is a system of permits. The DEC will be authorized to issue permits for up to 10 years for certain amounts. And this is for any water withdrawal in the state. And there's no restriction, once you have a permit, there's no restriction on where you can take the water or what use that you will put the water to. So just to review this, the concept that under riparian rights you don't own the water, that the water belongs to the people. This is a concept that comes from Roman law, from the Institutes of Justinian. In 529 AD, there's a powerful statement here. By the law of nature, these things are common to mankind: the air, running water, the sea, and consequently the shores of the sea. No one, therefore, is forbidden to approach the seashore, provided that he respects habitations, monuments, and buildings which are not, like the sea, subject only to the law of nations. And this doctrine, this statement in the Institutes of Justinian is the basis for the modern public trust doctrine. And it traces, in the United States, it traces its origin through the Magna Carta, because it is this doctrine from the Institutes of Justinian that was followed when King John was forced to relinquish private fishing rights that he had granted to certain noblemen. And the idea was that the crown only held those resources for the benefit of all the people, and that they could not grant private rights to certain individuals. This concept was recognized in the United States in the 1842 Supreme Court case that addressed a New Jersey landowner who tried to exclude others from taking oysters from the mudflats on the river. And he claimed that he had title to the river, and the court held that the Magna Carta had settled the question of who owns fish and wildlife, and that the king did not have authority to give away dominion and property of lands in colonial America. And the court further ruled that since the American Revolution, the people held public trust responsibilities for fish and wildlife, except for the rights specified in the U.S. Constitution. Then, in 1892, the U.S. Supreme Court held that a state cannot divest itself of its public trust interest. And this was a case in which the Illinois legislature had granted the entire waterfront of Chicago to the Illinois Central Railroad. They actually thought better of it before this decision, so this decision was to some extent helping them not carry through with that. But the court said that they could not do that, that the lands were held in trust by the state for the people of the state, and that the state could not convey this land because the effect would be to destroy the public's right of navigation and fishing. The public trust doctrine has been recognized in New York. In a 1998 case in Suffolk County, the court said the common law did speak on this subject of environmental regulation. And in enacting environmental mandates, we are merely discharging our obligation to those who are dead and those who are living and those who are yet to be born. And talks about the public trust doctrine as the basis for that. So I've explained a distinction between Eastern water law and riparian rights, and the Western states which have a prior appropriation system. It's interesting to see the map of the United States, to see these legal systems. The riparian rights states are here in the east. There are hybrid systems, which are the pale blue systems, and then in the white states are the ones with very hard prior appropriation systems. And to compare this map of the legal structure to the map of the rainfall precipitation in the United States. So you can see that that the areas which have very low precipitation are the areas with the permitting systems. And I'll skip over the details of the prior appropriation rights. I think that people probably understand generally, but some of the aspects of that is the oldest rights have precedence. The rights can be transferred away from the land, and they can be abandoned, whereas riparian rights cannot be abandoned. Riparian rights refer to the rights of the surface waters. The common law had different rights for groundwater because it wasn't understood exactly how groundwater operated. We now know that groundwater and surface water are very connected. But a very important case in New York addressing groundwater rights is the 1900 case of Forbell against the City of New York. And in this case, it was held by the highest court in New York, the Court of Appeals, that the City of New York could not take millions of gallons of water a day from land that they owned in Brooklyn to the detriment of a farmer in Brooklyn. The city had 2 acres. They were pumping 3 to 10 million gallons a day. And the city said that is not within the riparian rights that the city has for those 2 acres. You're pumping this for use elsewhere. You are harming the other riparian user, the farmer, and you cannot do that. The court said you can use eminent domain. A city has the right to use eminent domain, but then you will have to compensate the farmer for the rights that you have, for the water you have taken. You cannot just take it. This case is still good law in New York. This case would prevent gas drilling companies from taking water away from the land that they have leased and pumping it elsewhere. It does prevent cities and municipalities from taking water away from the watersheds that they own. The existing law that we have on municipal permits is basically to set up a system for requiring permits when municipalities do use eminent domain to take water from other locations. They can do that, and the statute sets up the conditions upon which they can take water from other resources, from other sources. Now, one of the consequences of this legislation is that there's no distinction if this legislation passes between municipalities and other users, but municipalities will still have the right to use eminent domain. So the question is, if municipalities have the right to use eminent domain and then can sell their water and then use eminent domain to acquire more water, what are the limitations on eminent domain? What are the limitations on what they can take by eminent domain and then resell? So there are questions about usage. I just wanted to say that the New York law on groundwater is very different than the law of Texas. In Texas, there are unlimited rights to pump groundwater. No limitations. A series of court cases recently reaffirmed if you harm the other users by your pumping, that's just too bad. So we have a rule in New York that is, it's actually the Forbell case established the American rule, which is that groundwater withdrawals have to be reasonable in the same way that surface water withdrawals have to be reasonable. An interesting case in Colorado recently, the Colorado Supreme Court held that with produced water from gas drilling is subject to the state's water laws. And this proposed legislation in New York does say any water withdrawal requires a permit. There is water in the formation in the Marcellus Shale. If water is being produced by the gas drilling companies, is that subject to the permitting requirements? The industry was very disturbed by the Colorado decision and sued, but I think they have dropped that lawsuit now. So the critiques of riparian rights is that it's too indefinite, and that if we're going to have markets for water, we need to have permits. So that is a pressure for this permitting system. I know several people went to a recent conference in White Plains about the wonderful water resources that we have in New York, how this is a wonderful opportunity for our state to benefit by selling water. Basically, permits are a form of prioritizing water. The permit holders will have priority rights over other users, and they serve to entrench the large users. So that's a big concern with this legislation. The only people who are entitled to have permits under this legislation are those who are using 100,000 gallons a day or more. All existing users are mandated to be given permits without regard to the use that they're putting it to or to the needs of other users. So I did want to ask Jack to say a few words about the concerns that the Coalition to Protect New York has with this legislation and the work that they're doing.
Hi, I'm Jack Ossent. I think several of you know me from last year in the same space here. Things have certainly changed. Seems like none of us have enough time to do what we need to do. Okay, a couple minutes. Major concerns on this water withdrawal bill are who's driving it, where the money came from to drive it. We've been informed by counsel to the Codes Committee in the Assembly, senior counsel there, that the chemical industry is behind this. We are wondering why the drilling folks have not come out publicly and chastise this bill if it in fact is not benefiting them. As far as we just recently learned yesterday, of course, you're all aware of this too, I'm sure that Assembly and the legislature's gone home until May 2nd. It's bought us some time to get more information out. We've got two statewide organizations pushing this bill, Environmental Advocates and CCE, Citizens Campaign for the Environment, as well as some national groups, NRDC. And we question the intent of their involvement around this bill, not to sever the environmental movement here, but we think that they're mistaken in pushing this through, getting it into a permitted regulatory environment and not ensuring that the riparian judicial relief system is carried over into the permitting process. So several of the points that Rachel has raised here are germane to that concern, that if we're going to move it into a permitted regulatory oversight, as several of you fought in these environmental battles for a long time, know that you go before an administrative law judge and you favorably can win those fights all the way up to the level of where the commissioner of DEC makes the final decision. He can override all of those administrative law judge decisions that you've accomplished in your fight against an environmental battle. So as Ben Price points out, you know, there's no democracy in a regulatory system. This is totally dependent upon a political appointee, the commissioner of DEC, that can override any of these hearings that are held within a permitting process. So our worry is, looking at who's pushing this or not pushing this bill and not being concerned about it, I think we need to draw some concern over it, and I urge you to read the bill. I think a lot of the environmental movement has not read this bill, does not know the total impact and the interconnections between this bill and other parts of the law. One of the big problems that we're having right now is that the Compact for the Great Lakes has sent a letter to all the elected officials in New York State pushing this. And it's being pushed because no other states have met their legal obligations under the Great Lakes Compact up to this point in time, and they're saying that New York should be the first state to do that. I think we need to step back and examine some of the players here, and I encourage all of you to read these bills. Thank you.